On May 25th, there were two complaints filed in the United States District Court for the Southern District of New York. And these complaints were filed by Gottlieb and Associates, which is nothing unusual. Gottlieb and Associates is fairly active in website accessibility litigation. But one twist is that these complaints were filed against universities. So specifically the University of Pennsylvania and Northwestern University. And so I'm on the Pennsylvania complaint right now, and I'm going to really summarize one of the sections of the complaint. And this is very similar to the Northwestern complaint. So the scenario is that defendant has a website, they offer goods and services through that website, and the services include information about the sports teams, the schedule of games. There's also the ability to purchase tickets to sporting events. And then there is also retail merchandise available, such as t-shirts and hats. And so now I'm going to tab over to the Northwestern complaint, and then we see third cause of action, violations of the Rehabilitation Act of 1973, Section 504. And this is in both complaints. And so with 504, you have a prohibition against discrimination on the basis of disability for federal agencies and recipients of federal funding. And so if you receive federal funding, the idea here is that it's very possible that now we have website accessibility being litigation being initiated against universities and other recipients of federal funding. And so this is not the only cause of action, right? And then, by the way, a cause of action is just a legal basis for bringing a lawsuit. The ADA is a cause of action here, and then Gottlieb and Associates also names the New York State and city human rights laws. But it was interesting that 504 has also become a part of these complaints. And so it's very possible that we see more litigation brought against recipients of federal funding. And so to prevent litigation, I highly recommend my ADA compliance course. This course is really designed to prevent litigation by genuinely improving the accessibility of your website. And then once you have a sense of relief from the most commonly claimed issues in litigation, then you can continue on to WCAG, full WCAG conformance, which is conformance with the Web Content Accessibility Guidelines. This is best practice for compliance with really any law. But this was a twist. We don't usually see this. I'm not saying it's never happened before, but I usually don't come across universities being sued, and I usually don't come across Section 504 being named as a cause of action.